Well, that's what we call a quick turnaround, and welcome everybody in to a Letecia Stauch update. Lots happened at the end of last week and already happening this morning. We are going to touch on what happens when a criminal defendant shoots the bird in the middle of trial. We're going to talk about one of the jurors who now we found out this morning was dismissed, and the interesting thing that happened at the end of the day yesterday. And we will discuss Letecia's daughter on the stand, what that testimony has been like so far. And of course, I will answer all of your questions. So thanks everybody for joining me here today. Hit that like button if you haven't already. Subscribe to our channel if you haven't already. We're pushing towards 250K subscribers. We have a members only video coming up on Wednesday, which again, I will mention a little bit at the end, what we're going to talk about and just some member benefits. Basically, if you're interested in that, then you can jump on the bandwagon now. But let's get to the end of yesterday's, or I should say last week's trial for Letecia Stauch, and listen to the discussion about the juror first, and then we will listen to what the judge does when he finds out Letecia Stauch was in fact potentially shooting the bird at people in the courtroom.
For seat number, and it's based upon where you are when you come back in that group and where you are seated. So in this case, I'm going to let everybody leave except for juror number 12, white hoodie, hoop earrings. I need her to stay for just a few minutes. Everybody else is excused. Enjoy your weekend. And juror number 12, if you can remain with us for a moment. All rise for the jury, please.
Everybody's leaving.
If we did our work right, I have the right juror. If we didn't, I apologize. I think you probably know why you might be here. Are you the juror that communicated to Mr. Combs that you knew one of the witnesses? Okay. You probably feel a little weird with everybody staring at you right now, but you did the right thing. Okay. This happens. Okay. It's really not that uncommon that somebody looks through the witness list and goes, I don't know any of these people. They don't recognize names. Names sometimes change. Sometimes they just don't remember the name, and then they see the face and they remember the person, and they do the right thing. They tell us that they know one of the witnesses. So who is it that you know, and how is it that you know that person?
So I know the expert witness, Stephanie Happ. I
Okay.
think it was her last name, distantly.
Okay. How is it that you know her?
So about 3 years ago, I was a worship leader at a church. My dad was the pastor. Stephanie's mother-in-law attended that church. Stephanie did not. Stephanie's mother-in-law is getting up in years and wanted to discuss with my father and I, as her pastoral staff, her wishes for her for her funeral. And she wanted to do that while she was still alive. So about 3 years ago, this person that attended our church gathered my father and mother and I at what turned out to be Stephanie's house, and along with her other children, to discuss her end of life wishes. So for about a couple of hours, we were in that home discussing funeral arrangements. And then we all greeted one another warmly, and I left.
Okay.
So to me, what's interesting is she didn't just know this witness. She was almost part of a counsel to this witness and a comfort to this witness in a time of need, whose mother went to their church. It's a certain kind of a relationship. So before I knew the judge let her go this morning, I thought the judge would let her go, especially because the defense objected and said this was one that they considered striking, just with a peremptory challenge. And while it doesn't seem like she would do anything unfair, she says she would not be biased. I just think in an abundance of caution with 6 alternates. And again, we always talk about how if in fact this person is guilty of the crime, we want a secure verdict. We don't want to open up any appellate issues. I think this would have potentially opened up some appellate issues if in fact they allowed this juror to stay on, which the judge, in my opinion, rightfully did not do.
Then, as it turns out, last October, this same church member of ours had an adult daughter who passed away from stomach cancer. Because I was part of the clergy of this thing, Janice asked me to sing at her daughter's funeral. So I did that. And at that funeral, I saw Stephanie, greeted her, gave her a hug, told her I was very sorry for her loss, and we've gone our separate ways. So those are the 2 times that
it's just too much of an emotional relationship and attachment, in my opinion, with somebody involved in the case. Now, again, would that necessarily make her change her mind? I don't think so. But we just don't usually in court cases, especially in a case like this, we usually do not allow things like this to happen. So it's not surprising at all that she was let go, even though she seems like a very nice lady. I'm not saying that she would have been unfair or biased or anything like that. I just think when they're involved in the case and it's a state's expert witness, I think in an abundance of caution, the judge did the right thing.
I have seen and spoken with Stephanie.
Okay. So I have to ask this question. Did you, and I know it's going to sound kind of foolish, but did you or did she mention anything about this case to you during either one of those instances? Do you or would you be able to judge her testimony just as you've been able to judge everybody else's testimony in this case?
Absolutely.
Is there anything about the context that you've had with her that would make you say, you know, I'm going to believe her because I know her, or I'm going to disbelieve her because I know her?
And it's so weird to see Letecia Stauch over there, like kind of giggling and smiling in some very weird moments.
Do you think that you can weigh her testimony just as you would weigh the testimony
juror,
of any other witness in this case?
The juror absolutely did the right thing to tell them, 100%.
Do you believe that you can still remain fair and impartial? Do you believe you can still remain a fair and impartial juror in this case, even though you've had some contacts with one witness and not others?
I do.
All right. Here's what I'm going to do. I'm going to send you back to the jury room. I want you to wait there for a couple of minutes while I talk with the lawyers, and then I will get back to you. Okay. And what you can tell the jurors, if somebody asks, you can tell them that you had a discussion, or we had a discussion here, because you disclosed rightly that you recognized one of the witnesses after you.
It's also a good reminder to the other jurors that if you guys recognize somebody, the right thing to do is to let everybody know, although now they're going to see she was struck, so they might think twice, but she handled this perfectly, this juror. Because a lot of times you don't recognize somebody's name and then you see them and you recognize them.
Saw them, and we had to ask you about that. Don't tell them who the witness was that you knew. Don't tell them what our conversation was, anything else like that. But at least this way they'll know what the conversation was, and they will know that the right thing to do in a situation like this is to say, hey, I know one of those witnesses, and let us know. Okay? All right. All rise for juror 12, please. Seated. Record should reflect that continuing to serve as a juror in this case. Prosecution?
No, Judge. The juror was very conscientious, brought this information to us immediately, it sounds like. Talked about 2 passing interactions that she had with Ms. Happ some years ago, and indicates that she can still be very fair and impartial in this case, and is not going to give her any special deference or anything like that. So I don't think there's any reason from our perspective that she would be challenged.
Perfect argument by the prosecutor, because the standard is fair and impartial. She said she could be fair and impartial. She said the magic words. If the judge wants to allow her to stay on, it's within his discretion to do so. Perfect argument by the prosecutor. Defense also makes a good argument as to why she should go.
Defense?
I'm going to move to have her excused for a couple of different reasons. One, I'm not alleging any bad faith or anything on the part of this juror, but it appears that it's more than a passing connection. It sounded, at least what I was gathering, it sounded like she was hoping to do end of life planning for Ms. Happ. I thought it was her mother, that there was a couple hour long meeting at the house, that there was a connection with a shared church, a religious connection. Part of the issue is, Your Honor, this is not just a lay or perceiving witness. This is an expert witness whose opinion these jurors are going to have to determine the basis of their opinion and how they value their opinion and so forth. So it's not just whether she would give her more credibility. It's also how that she would weigh her expert opinion on this, and it's expert opinion that is key to this case. Ms. Happ has identified the gun in question that she testified about as being the gun that actually killed Letecia Stauch. Furthermore, they're going to have later evidence that is going to put Ms. Stauch's DNA on that gun. And so there are a lot of circumstantial. I mean, this is pretty direct tie with Ms. Stauch to the weapon that this witness is saying actually killed Letecia Stauch. So based upon that, I would say it's a little bit different situation, because it's an expert and it's her opinion that she's going to be judging, and she does have a relationship with her. Further, Your Honor, I can say that that juror was one of the ones that we had a lot of debate on, as far as whether or not to use a peremptory challenge on. It was down. She was our last one. It was her and another juror. Whoever we used our last peremptory on, the choice was between her and that juror.
There's no real way to prove that, but he says it. And the judge actually, when he makes his decision this morning, he said, I'm going to go back, or I'm sorry, tonight at the end of this video, he says, before I make my decision, I want to go back and see if there was discussion around this juror, what her questionnaire was. And he does some research. He seems like a really great judge, which I know a lot of you in the chat love him and love his voice. But, the lawyer could be saying, well, we were even going to strike her, maybe, judge, which goes more towards their argument. But it's really hard to ever actually know if that's the truth or not.
Juror, had we known that she had this kind of connection with
now that I believe
expert witness,
that if they would have known they had a connection with this witness, I think she would have been struck for cause. I don't think they would have needed to use a peremptory, but if they did have one left, they absolutely would have used it on her, in my opinion.
It's a peremptory challenge on her. We're, I think, more than or close to halfway through this trial. We have 6 alternate jurors on this case. I think that it's a cleaner to excuse her at this time with her things and move one of the alternates on, and that way we can go forward.
All right. I want to think about this over the weekend. I'm also going to review her questionnaire again as well, and also the seating and strike chart to see where we were, or to see how the peremptories shook out. I don't know, since she was not excused, whether that will help me a whole lot, but
Probably
I
not.
want to look at 2 of those things, and then I will make a decision before we start trial on Monday.
Okay.
Go from there.
Yeah, we just have one other issue to bring up.
Go ahead.
Judge. Are you ready for it now?
A bunch of people are saying he sounds like JB from WFLA. That's hilarious. We love JB.
Okay. It's come to our attention.
Hold on just a
Okay.
second. She can go ahead and go, and we'll see her back on that. Okay, Mr. Allen.
It's come to our attention that during I think most of the afternoon session of witnesses today, that the defendant has been flipping the bird potentially to witnesses or to our family that are here for Gannon. And there have been pictures that have been passed to me during this process. One, it's disrespectful to this court. It's disrespectful to this process. And I would ask the court to admonish her to refrain from acting this way in the future during the pendency of this case.
Okay. I've not seen any of that, but on the other hand, the defendant is to my far right. I can see her some on a screen, but I'll just take it as is.
Nobody's arguing she didn't do that, in case you didn't notice. But the defense lawyers say nothing. Letecia Stauch says nothing. Judge says I can't really see her. If you notice today, she's sitting between the 2 lawyers with a much more direct view of the judge and not necessarily a hidden view of anybody else. So my guess is that's purposeful where she's sitting now, but let's hear what he says to her.
Ms. Stauch, what you need to understand is that I can control the conduct of an awful lot of people in the courtroom, including yours. And don't do that. Don't show that kind of, don't be making
I can control the courtroom, the conduct in the courtroom. Don't do that.
disrespectful gestures to witnesses, to people, to family members, anything like that. You need to understand that if that continues, I can have you removed and the trial will continue without you. And you will sit in a holding cell.
Do you see her smirking? Like, again, this is kind of what makes you think maybe there is something going on upstairs, but he's like, I can have you removed. You can watch this from somewhere else. Don't do that. It's disrespectful. It's not how we act in a courtroom.
In this building, and every time we take a break, I'll bring you back up to ask whether or not you can conform your conduct to what I'm requiring. If you choose to act in a disruptive behavior or disruptive fashion, I'll just have you removed and we'll continue on without you. And then we'll check and see if you want to come back and behave in a respectful manner. So I'll just leave it at that. And we will see where we are on Monday. All right. All right. Court will be in recess. You can leave everything here.
A lot of you are saying, wait till you hear what he says this morning. I did not hear it. I heard him talk about the jurors, but I did not hear what he said this morning. If somebody has a timestamp or can send me a clip of it from Law and Crime or wherever in the next like 5 minutes, then I will try to play what he said this morning as well. Or you guys can just let me out or let me know what he said this morning. EJ, hi, lawyer, fam. Sorry, I've been MIA. Last PET scan yielded some bad news. I'm sorry to hear that, EJ. Cancer has spread to several news spots. Thank you, Peter, and my lawyer, family, for your support and positivity. Lawyer, cancer warrior. EJ, I'm really sorry to hear that. Hopefully you can find some time to be in the chat because we're here for you. Hang out, bring some positivity, hopefully some entertainment, some education while you're going through this tough time. So we're really sorry to hear that. You will be in my prayers for sure. Kendall, what sort of deliberation commonly takes place during jury selections? What sort of questions lead to discussions and what negotiations look like? So it's not really a lot of negotiations, but we discuss whether or not we think this person is going to be fair and impartial to our client. If they, had a strained relationship with their mother, or they, have a certain kind of job, or if they live in a big town versus little town, all of it with different research kind of comes into play as to whether or not you think they'd be the right kind of juror for this case and whether or not you think they'd be fair or unfair towards your client. So we don't have a ton more time today. If there is more that the judge said, people are saying the judge laid into her this morning. I wish I would have seen that. I did not see that the judge lay into her this morning. So somebody can post that clip, or we can kind of post it in the video description. We have a members only live coming. Rebecca, thank you so much for this super sticker. So we have a members only live coming Wednesday. We are going to talk about the Last Kingdom movie. We're going to talk about our favorite shows that we've ever kind of streamed or had or watched together, non-legal shows. And I'm still looking for probably kind of one more topic. So we're going to jam pack the members only video again. It's not going to be any law-based or anything like that. Excuse me. Because I like to save that for everyone. It is going to be more based on just fun stuff, personal stuff. Let me see. Anna Wade sent it to me on Twitter. For some reason, I'm not like logged into my Twitter on my computer. So let me email it to myself here. All right, let's see what we got. We are going to pull this one up and just go and see. All right, it's 5 minutes long. We're pushing it, but let's do it. Thank you, Anna. That's the wrong one. We're going to have to go 1.5 speed because I'm running out of time.
Mr. Allen, I'm going to direct this question to you because you made the comments on Friday. You had indicated that you had received some information, and I thought you said some photographs regarding the defendant's conduct, which potentially could be construed as extending the middle finger or flipping people off, including a witness, perhaps family. Do you have those photographs?
I can get them printed. Basically, it was just screen captures from what was being broadcast on WebEx, which I think the court may also have the same things that I saw.
Do we have that now? Okay, so we will upload some of that so that there is some record of what it was. You may have all noticed that the tables have been slightly reconfigured. They'll be reconfigured again after or at lunchtime, largely because I think that table where it is generally wasted space. So what we're going to do is give you.
So we're going to see even a new table configuration after lunch is over today.
A more narrow one and slide that table over further. I'll move that table then to the back so that you can put stuff on it. You may still be able to use it to some extent, but nobody will be able to sit at it. Ms. Stauch, you have the right and obligation to be present for your trial. Being present permits you to see the evidence the prosecution is presenting against you. It permits you to communicate with your lawyers while that is going on and assist them in your defense. You also have the right for the jury not to see you in restraints that are commonly associated with being held in custody or confinement. That way, the jury does not see you as a prisoner or someone who is in custody and is not prejudiced against you because of that. These rights, however,
which to me is a big up to lawyers that write these rules in America, that even though there's enough evidence to hold you without bond, we still don't want you to show up in shackles and in an orange jumpsuit for trial. I mean, I think that's really fair in our justice system. I just want to point that out.
Are not without limitation. While you have the right to be present for your trial, you also have the responsibility to behave with the respect and decorum required for this formal proceeding. You also have the responsibility to behave in such a fashion as to make the use of additional restraints unnecessary. Sometimes during trial, a defendant chooses to act out. The likelihood that that will happen, in my experience, seems to increase the longer the trial takes and the more serious the charges are. And I know that right now we're in week 4, or we finished 4 weeks. We're starting week 5. You aren't the first defendant to act out. Probably not going to be the last. I cannot imagine the pressure a defendant feels during any trial. It's not uncommon.
Very nice and understanding of him so far.
For a defendant to disagree with certain testimony or dislike a witness or a victim. Nevertheless, you cannot act disrespectfully in words or actions. First of all, never helps you out. You've already heard one juror submitted a question regarding his observation of your conduct. They don't miss anything. It also makes your attorney's job much harder.
Ain't that the truth? They don't miss anything. As we've heard in juror interviews post-trial, they are always paying attention.
They need to focus on the evidence presented and how to counter that rather than your conduct in the courtroom. I am also aware of the practical realities that exist in this case. I could hold you in contempt for your conduct in the courtroom. That would mean that I could impose a sentence of up to 6 months of jail for each incident of conduct which I find to be contemptuous. However, in a case where a defendant is facing decades or even life in prison, if convicted, a 6-month contempt sentence does not seem to be much of a deterrent.
Ain't that the truth? It's like she did not seem to care yesterday. She doesn't seem to care today. Seems like she knows she's probably going to prison for the rest of her life. So she's probably thinking, whatever, that doesn't scare me.
But that does not leave me without a remedy. We have moved the tables around. You are now sitting in a chair that does not rock or swivel. You will be directly facing the bench, and you will be more in my line of sight. I want to caution you against certain actions, such as waving your hands around, trying to stretch your fingers out, and leaving one of them more prominent than the other. Those acts would be, in my opinion, disrespectful to the proceeding. It's disrespectful to the court and the legal process. I also view it as a form of witness intimidation and an attempt to influence presentation of evidence in this case. If that conduct occurs again, it would be a violation of the decorum I expect in this case. Everybody that's sitting in the gallery sees signs that have already warned them of the same kind of conduct. You can't do it either. I may then impose other remedies. I could simply have a bolt installed on the underside of the table and have your hands cuffed to that bolt.
Cool.
You wouldn't be able to use your hands. The jury wouldn't be able to see the handcuffs.
Ooh. He's like, so we can make sure the jury doesn't see the handcuffs, but I'll still bolt your hands to the bottom of the table so you can't even lift them up the entirety of the trial. Eesh, that's rough.
It would be uncomfortable. I could have you removed from the courtroom and the trial would proceed without you. You would not be returned to the jail. Instead, you would be held in a holding cell in this building. You know how uncomfortable they are. You would then be transported back to the courtroom at every break to see if you had changed your mind and agreed to behave in a respectful manner a courtroom requires. And you would be brought over for the next day of trial and we would start all over again.
Interesting. I would have loved to see this guy with Darrell Brooks, right? I think Darrell did a good job, but I just would have been interesting to see the kind of different styles go at it. Okay. I am a couple minutes late now. I've got to run into a meeting with another lawyer in my firm. I appreciate everybody joining me. Hit that like button, hit that subscribe button. Sherry Lackey and all the new members, welcome. We're going to have some fun Wednesday. I got to bounce though. Thank you everybody for joining me. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.